Hey good people, the firearm bill was just released and I read all of this so that you don't have to. There are several big changes, and even if you don't own a gun or live in West Australia, this bill serves as an example of how legislators are relying on angels to be in government. Up front, I will let you know that I do own a firearm, so I have that bias going into this. Let me know if you thought that bias crept into my critiques or if you thought I was fair on this one. The first change is the new maximum number of guns you can own. Depending on your shooting activity, be it competition or hunting/target, you can either own 10 guns or 5. The intention behind this is to limit the number of guns that can make it onto the black market if a gun owner gets robbed. I think it's a fair concern and it's an obvious way to address it. I think a better solution would be to fund policing and target burglars instead of law-abiding citizens, but police resources are limited and politicians only have one tool in their belt, which is to write legislation, and so that's what they've done. What's a property letter? It's the letter to the police that satisfies the genuine reason/need part of your application. If your letter is rescinded by the farmer, then you now only have 28 days to get a new property letter or lose your firearms license. Why might a farmer rescind your property letter? According to page 12, suitability of land for shooting, properties will have a limit to the number of licensed shooters. So, if Farmer Joe gets a friend that he cares about more than you, he might rescind your letter so that he can give it to someone else. No problems with you or your character, but this property can only give out 10 letters, not 11, even though each person only shoots once a year. Further down on page 11, there is a way bigger pain in the ass. The new legislation will require express approval. I think they mean expressed approval from the occupier of the land to shoot on any specific occasion. The intention here is clear. They intend to make it such a hassle for you to ever go shooting that you never do. And the next sentence is, a written approval will be needed for every new land a license holder wishes to conduct shooting activities. So, if you satisfy the genuine reason question with a property letter from Farmer Bob in York, and your buddy that shoots at a different property over there in Gin Gin invites you to come plink some buddies with him, you'll have to get another property letter. This feeds back into why a farmer might rescind your letter in order to give it to someone else. Meanwhile, in other states, the same way you can get a license for a car and then you can drive any car, anywhere, in West Australia, you'll get a license, but you can only drive this car from here to there and back. If you want to drive anywhere else, you'll need to get another license. I think they're just trying to make it as difficult as possible. In other states, you can even go shooting on state land. 4.1 says, a firearm authority will not be granted if the applicant is not a fit and proper person. How do you determine who is fit and proper? And more importantly, who gets to decide? Does the commissioner compare you to Mr. Darcy, who is both fit and proper? I think this clause is probably the worst because any accusations leveled at you about being not fit or proper will be challenging to disprove. And this perfectly illustrates the latest trend within poor legislation. Legislators will use words that convey a feeling of assurance, but in a court of law, they're so intentionally vague that it's impossible to disprove any accusations. Fit and proper requirements is another example of how legislation has been crafted to make you feel as though the law is on your side, but in actual fact, should you give the commissioner or anyone in government a reason to look at you twice, you'll find that they have all the power they need to make your life hard and you'll have no path of recourse. How might your views, opinions, and attitudes be intentionally misinterpreted if you drew the ire of the state? How might your living conditions or domestic circumstances be used to paint a picture of someone who is not fit or proper? These kinds of clauses are designed to be used on a whim whenever you become inconvenient. You may not be the person they are interested in today, but in a year, 2 years' time, maybe there's another pandemic or a referendum or a war in Israel or any other divisive political topic, and you aren't on board with the mainstream narrative. At that point, if the commissioner says you are not fit or proper, who are you going to appeal to? Politicians, judges, news, and the public are all going to take the side of the commissioner because he's the commissioner and you are nobody. On page 25, we have a good example of reasonable exclusions. 1.1.1 If within the last 5 years a person was convicted in any jurisdiction of assault or violence, then the Commissioner will not issue you a license. These are reasonable exclusions that are fixed and measurable. We can point to something specific and say that right there, that is the reason that you have been denied. This was the law before, it's the law in all the other states, and is actually the law in the United States. It will be open to the Commissioner to consider any person's associations when considering any matter pertaining to a firearm authority. This is the principle of guilty by association. While this may be intended to address concerns around bikies and gang members, it's going to impact everyone else. This means that your associations could be used against you, putting your license at risk based on your connections and not your actions. 114 Health Requirements states that you can be required to get a mental health check every time you want to renew your license. That's a huge financial cost and a massive time burden. Commissioner's powers to cancel your license. Amendments of Firearms Authorities says the Commissioner can amend your license by adding or removing a purpose. And then if you have 0 purposes for your license, then you'll lose it. All he has to do is send you a written notice to let you know. This is unconstrained power to remove your license on a disinterested whim. It's reiterated in 5.5 cancellation and refusal to renew, and again in mandatory cancellation or refusal to renew, and again in discretionary suspension. Similar powers are given to police officers. The power to judge you not fit and proper at the drop of a hat and remove your guns from your possession. Police are people. They're fallible, prone to bias and prejudice, just like we all are. That's a lot of power for a cop on the beat. And how's this for police power? Under offences in relation to police powers and enforcement, you will be committing an offence if you fail to answer any question asked by police. You could have a lawful excuse, but what counts as a lawful excuse to exercise your right to remain silent? Page 46, Protections for Persons Making Disclosures of Information, is another example of feels good until you think about it. It says that a person can make a disclosure of information to the Commissioner and their identity will be protected, which is good, but they will also be protected against civil and criminal liability, provided the disclosure is made in good faith. How do you know if it's made in good faith? Imagine this: a disgruntled ex-employee or ex-girlfriend could call up, lie, and accuse you of being mentally unfit, and they could come and take away your license that you worked so hard to get. I mean, how would they know if the ex-girlfriend is acting in good faith or just lying? They couldn't know. But if they guess wrong, they will be hung, drawn, and quartered. So they're going to err on the side of caution every single time and come and take your property. The bad faith actor that was your ex-girlfriend, she's protected from character defamation or any other legal justice that you might try to bring her way. And imagine if you're friends with this guy. He's just gotten divorced, his ex-wife's accusing him of being mentally unwell, they've come and taken his license. Now you've got to worry that they might use the association clause against you. Now your buddy has got no friends, no girlfriend, no hobbies. Now he really is mentally unwell. And while we're on the subject of indemnity, check out this sentence in 12.2. Disclosure of information by the Commissioner. If a disclosure of information by the Commissioner is made in good faith, the Commissioner will be protected against civil and criminal liability in respect of that disclosure. All of 12.2 means the Commissioner can disclose all of your information, everything about you, to any other state agency, provided he is of the opinion that it is in the interest of the public. Who decides what the interests of the public are? He does. Is every action he takes in good faith? You betcha. Honestly, there is no accountability. If Telstra disclosed all of your information, even by accident, they would be sued. But let's finish on a high note. 14.3, Review by the Minister. This sentence just states that in 5 years' time, they will review the operational effectiveness of this bill. Whilst I'm concerned about the metric they will compare success to, the LRC report, I do think that it is appropriate for all incoming legislation to set a review period in order to examine what effects the bill is having and whether those effects are in line with our goals. To summarise, these are the changes to WA's firearm legislation. What I'm trying to do here is just point out that this legislation would be fine if the people administering the law were benevolent saints, with the ability to see into your future and into your soul. But sadly, we are not governed by angels. The ability for someone in a position of power to abuse that power and then be unaccountable for that abuse is rife within this legislation. Some of this character judgment legislation may be fine if there is a strong disincentive to not get it wrong. Like, there has to be some kind of punishment for messing up someone else's life, and there just isn't. You're guilty by association, or because you like the wrong Facebook group, or because we deem your character to not be the right character. And if it turns out that you're actually a great bloke and they got it wrong, oh well, you won't even get an apology. Here's my final opinion of this bill. West Australia is not America. It doesn't have a gun problem. And I think these new laws are just so that come election time, the Labor Party, which holds 53 out of 59 seats in West Australia, has something to talk about that Australians will respond to. Australians in general don't like guns and don't like American gun culture. And if you criticize these laws like I've just done, you open yourself up for easy political attacks, which is why no major party will oppose them, even if they don't agree with them. This bill serves as an example for poor accountability for our government officials. Some of the points that I've criticized within this bill, I could get on board with if there was an ability for a private citizen who had been wronged to hold that office accountable for their actions. That would provide some incentive for officials to behave properly, at the risk of being taken to court, given a fine or demotion or jail time, all of which are punishments for private corporations acting in the same way. If you're sick of government solving problems that aren't really problems, or you want to see this legislation changed for any other reason, send an email to firearmsactreform@police.wa.gov.au by Tuesday the 14th of November. If you only have so much time, check the comments. There is a preloaded message where you can just Control-C, Control-V. If I provided value to you and you want to be informed about incoming legislation so that you can make an educated vote, then subscribe and I'll keep reading these bills for you. Links to all the resources is in the description. And remember, you were born free.